Hello, my name is Pablo Ibanez Colomo. I am a professor of law at the London School of Economics, and I'm also a visiting professor at the College of Europe. At both institutions I teach competition law and the regulation of network industries. So this presentation provides the background for the discussion that will take place on the 8th of June concerning line of business restrictions in competition law and regulation. Then when we think about line of business restrictions, immediately the regulation of network industries comes to mind: telecommunications, postal services, transport, energy, and so on. So what we realize is, first of all, that this line of business restrictions are fairly common in the regulated network industries. And the second point we realize is that there is a great degree of variation across network industries when it comes to the intrusiveness of intervention. I think it is useful to think of line of business restrictions as points along a spectrum. So then there are less intrusive forms of line of business restrictions, and this is something that was emphasized in the background note that has already been issued, and others that are more intrusive. Right? And there is also a great degree of variation when it comes to the way in which the different regimes approach line of business restrictions. Some are prescriptive, provide for a solution. Other regimes provide for a menu of options that depend on the particular circumstances of the industry, of the evolution of the liberalization process, and the degree of innovation, and so on. So then, as I was saying, it is useful to think of the different options as points along a spectrum. This is one way of looking at this matter. So there is, first of all, a transparency obligation, and there is, at the other end of the spectrum, structural separation. And in the other point of the spectrum, there are more or less intrusive forms of intervention, and one can even subdivide these different points along the spectrum further. For instance, there's a variety of forms of functional separation and so on. But what is useful for the time being when it comes to this discussion is that all these forms of intervention seek to separate different business activities of a vertically integrated operator. And the second point is, well, there are different forms of intrusiveness or different degrees of intrusiveness depending on a variety of circumstances. So what determines that a regulatory regime will go for a more intrusive or a less intrusive form of separation? Well, one key factor, if we observe the different features of the regulated network industries, is the rate of innovation. And what we notice is that legislatures tend to be more prudent when the degree of innovation on a given industry is relatively important. So then legislatures and then regulators themselves will become more reluctant to go for the more intrusive forms of intervention when there is a great deal of innovation. In a similar vein, when the loss in terms of efficiencies is important, legislatures and regulators will also be more prudent when it comes to contemplating the more intrusive forms of intervention. And I think these two ideas are very useful to make sense of the variation that we observe across network industries. So at one end of the spectrum, we see the telecoms regime. And the telecoms regime sees with reluctance the more intrusive forms of intervention along these lines. So by more intrusive forms, I mean, well, on the one hand, functional separation, and on the other hand, structural separation. Just to mention two examples from the EU regime for the regulation of electronic communications, which is the one with which I am more familiar, we realize that functional separation, so the second more intrusive form in the spectrum I provided, is confined to exceptional cases in accordance with the Electronic Communications Code, and it is only, or it would only be available to a regulatory authority when other forms of intervention have failed. Right, so this is one key idea. Another key idea that will be discussed, of course, concerns the possibility of structural divestitures. Again, great reluctance. And a good example in this sense comes from the UK regime, where my main institution is based, which eventually did not go for the structural separation, even though the possibility was considered at a given point in time. Okay, so this is one key idea. And another key idea that ties well with the discussion I was introducing before is the fact that the telecoms regime is not prescriptive when it comes to the choice of remedies. Instead of providing for a particular solution when it comes to line of business restrictions, it contemplates a menu of options from which regulatory authorities will have to choose. So then it will depend on the features of the relevant market. It will depend on the degree of competition that has been injected as a result of intervention. And it is only after a case-by-case assessment of the features of the market, which is in fact examined in accordance with competition law principles, that regulatory authorities will go for one solution or the other. And again, and in the same vein, the tendency is to regulate less than more, and the clear bias of the EU telecoms regime is not to go for remedial intervention unless it is shown to be necessary in order to sustain or promote the competition that has been created as a result of intervention. And this same philosophy applies when it comes to the remedies. So then less intrusive remedies are preferred over more intrusive remedies. Right? So this is the logic of the telecoms regime. Again, two key ideas. Because of the degree of innovation, because of the efficiencies that may be lost, there's great reluctance to go for functional or structural separation. Second key idea, there is a form of intervention, or there's a form of regulation that leaves a menu of options and that is clearly biased against intervention. At the other end of the spectrum, we see more prescriptive regimes where the degree of innovation is less important, or has at least historically been less important, which is why there is less reluctant to go for more clear forms of separation, which leave less to the individual circumstances of a particular market or the degree of evolution in a given industry. Then what are the lessons that we can draw from this overview when it comes to online platforms? Well, one first lesson we can draw, and this is something again that was emphasized in the background note, is that in a way EU competition law can mimic the logic of these regulatory regimes. So then on the one hand we can see access obligations that may be imposed in the context of a refusal to supply, for instance. And what is notable about these access obligations that may sometimes be imposed is that they come with a sort of line of business restrictions that we observed before, including the possibility of imposing transparency and non-discrimination duties. Well, it is typically the case, in fact, that an access obligation will only be a meaningful one insofar as it provides for these additional obligations. And then the other point is structural separation is exceptional, but is not unheard of. And we have seen intervention along those lines, both in the US and in the EU regimes, and of course in others. A key example in this sense would be the E.ON case decided in 2008 by the European Commission, where this sort of structural separation was imposed. And what is notable is that this sort of structural separation that came about in this particular case mimicked the sort of remedies that a regulatory proposal was contemplating at the time. Right? So this is something that has been, or this is a discussion that is known in the context of sector-specific regulation of and network industries, and is something that is, of course, now more prominent in the context of online platforms. Right, so when we think of online platforms specifically, well, we have one example that I think illustrates how competition law can provide for this sort of line of business restrictions. In Google Shopping, essentially the remedy as implemented amounted to some form of functional separation. Shopping was separated from the rest of Google, and with this separation of the shopping unit from the rest of Google came other duties that we observe also in sector-specific regulation, such as a form of accounting separation, and of course the key point of the case were the non-discrimination duties that were directly imposed by the European Commission in its decision. So we see that a competition law can mimic that. And of course, if we engage in a discussion about the convenience of going beyond the application of competition law to online platforms and imposing some sort of a sector-specific regime, well, the debate about this line of business restriction will become even more relevant. Right? So then, in that regard, I think issues to note, when engaging in this discussion is, well, in the different forms of intervention that we saw in sector-specific regulation, well, online platforms come across as closer to telecoms than any other. This is so, first of all, because of the rate of innovation and the potential for change in the industry. So then the fact that the telecoms regime was so flexible is to a large extent a function of the fact that when it was adopted, it was known that technology and innovation could have, in fact, address some of the perceived problems at the time of the adoption of the regime in question. Right? So then this reality explains why the telecoms regime was conceived as a flexible one, providing for a menu of options and not prescribing a rigid form of separation. Well, if this is the background, it would be natural to adopt a similar approach in relation to online platforms, because the concerns would of course be the same. Right? Then this is all the more so, one could argue, considering that efficiencies in relation to online platforms are not entirely understood. So this is something that was explicitly mentioned by the Special Advisor's report for DG Comp in page 70, where they acknowledge the limitations in terms of the understanding of the functioning of these online platforms and the efficiencies they generate. Right? Then, against this background, one point for discussion is, well, would it not be natural, if there is ever regulation in place, or if there's ever competition law forms of action considered, would it not be natural to leave all the options open instead of going for one rigid solution, such as structural separation across the board? Right? So this is one key idea. And then there are other differences between online platforms and the telecoms regime. I think the one with which the analogies are more natural, that I think deserve to be discussed at length, including in the roundtable that will follow this presentation. So then one key difference is the fact that in telecoms, the issues and the markets are relatively narrow and well understood. Essentially, in telecommunications, there is a relatively small set of issues that can be summarized in around two. Well, access to the local infrastructure, what comes to be known the local loop, or the part of the network that cannot be easily duplicated. That is one key issue. And the other issue is interconnection between the various of the different networks. Right? Then the fact that there's two big issues and that all markets around are relatively narrow and well understood means that it is a relatively manageable regime. If we look at online platforms, then there is much greater diversity. And I don't think this issue in itself is controversial. There is diversity across a whole range of issues. I will mention just two. Well, the fact that in online platforms, some segments may be competitive. In fact, the leader or the operator of the online platform may not even be vertically integrated. That's one question. The question is, well, the issue of indispensability varies also greatly from one market to the other. So there is no uniformity when it comes to the relationship between the different levels of the value chain. So then the fact there is greater diversity means that intervention by definition will be more complex. So just to illustrate, and in fact to entice the discussion, I can think of some examples. Think of a platform operator running an app store or a platform operator running an online marketplace. Well, in some markets, the app store or the online marketplace may not be important. There may be an adjacent market to the app store, to the online marketplace, where in fact the platform operator running the app store or the online marketplace has an irrelevant market share, or maybe has a relevant market share, but is facing very strong competition. In other ones, it may be dominant across the board. It may be dominant in relation to the App Store and dominant in relation to the online marketplace. So this is the issue of diversity. And as I was explaining before, it may be a function of the fact that actually the need for access may vary greatly from one market to the other. Right? So then the fact that there is greater diversity in online platforms means that there are several questions to raise when it comes to intervention. Would it make sense to rely on a single remedial approach? Would it make sense to impose a single remedy across the board? Or is intervention going to change from one market to the other? And if we're going to adjust intervention, what is the appropriate level at which intervention should be adjusted? Should we adjust intervention from one platform to the other? Would that make sense, considering, again, that within a platform there is greater scope for diversity? Or should we go market by market? And if there is greater diversity, and maybe intervention should be fine-tuned, well, what are the consequences when it comes to institutional arrangement? What sort of intervention, what sort of model for intervention should be used given this diversity across the board? So those are the questions which I hope will form the basis for an exciting discussion in 1 month time. Thank you very much.